term and termination. I've seen so many contracts that don't have a term, meaning a duration of that contract, and don't address termination at all. But guess what? Someone in the contract wants to terminate, and now they don't know what they're supposed to be doing.
Mm.
So important. So let's talk about term first. The term is the duration of that contract. It can be anything that the parties agree for it to be. It can be a day, a month. It can be perpetual until terminated, meaning that it just goes on and on and on until someone actually terminates the agreement. Very important to put in there because you want to make sure that, again, everything is making it very specific. You want to make sure that you can have a controlled environment of how you run your business. So if
Right.
you're doing business with a vendor or you're getting into a joint venture agreement or something like that, let's do the vendor, and someone is supplying you with the cups.
Mm.
You may want to have in that vendor agreement that it's perpetual until terminated, meaning that it's just going to go over and over. You can have that I'm going to do this for 6 months and then it automatically renews until I terminate it. Why would I say that? Because you don't necessarily know what's going to happen with that vendor. You don't know if that vendor is going to be good. You don't know if that vendor is going to be satisfactory, especially if it's a new person or a new company. So you want to make sure that you can now take that 3 to 6 months or whatever you put in your contract, and you want to make sure that you can now assess whether you want to continue. And then it continues if you want to continue. And if you don't want it to continue, you can terminate. So it's a good way to control your business rather than having nothing in your contract saying that you
Right.
can terminate, because then that's going to be an issue because you're going to have to get into, well, how do we even terminate this? Do I have to give notice? Do all these things. So I have kind of a list here with the termination. So the term and termination. Termination, you got to address if you're going to have it automatic or not. I've had so many questions from clients about, well, does this, am I even still in this contract or not, because it says that it's automatically renewed, but then I sent them this termination and then they didn't address it, and then now are we in the contract or not? Like it gets very confusing sometimes. So address how it's going to be terminated and what those notice requirements are. So if I say I have a contract with you, but before it gets automatically renewed, automatically renewed for another year, another 2 years, or whatever the case may be, I'm going to go ahead and put in that notice requirement. 2 weeks before it gets renewed, I write you a letter, I send you an email, I'm going to terminate it. That's notice. All those things that I'm talking about are not things that I'm pulling from the air. These are things that the parties have to agree on to begin with. When you sign that contract, you are agreeing to these procedures. There's not one set way that you can pull from the Florida statutes or something that says this is what termination has to be. There's lots of different policies that companies will use, and that could be one of them. That 2 weeks notice thing, it could be 2 weeks, 3 weeks, it could be whatever the parties agree. Can either party terminate? Is a good question to ask too. Do you want to make it unilateral? Does it have to be by mutual agreement, meaning that you both have to agree? Now, that's not a favorite of mine because if I'm displeased with you, are
Yeah.
you going to agree to terminate? Probably not. So you have to put in conditions. It would be beneficial for your company if you put in conditions that allow you to go ahead and terminate that contract. So that's why a lot of times you'll see in larger contracts, and I've written many of them that talk about the conditions that can lead to termination. It can be a breach of an obligation to pay, for
Mm-hmm.
example. You don't pay me, you're breaching this contract. But it states it in the contract that a breach of something that's material to the contract, something that's an obligation that you had. If
Yeah.
you don't do it, then I can terminate this contract based on you not doing it. There's different other things. I wrote sort of a list of it. People talk about, depending on what kind of contract you have, that if the party engages in unprofessional, immoral, or fraudulent manner, I've written that in contracts before because of the type of business that my client has. They don't want someone who's going to try to, like, they think is defrauding them or is doing something to hurt their business. They want to be able to terminate.
Right.
Okay, I wrote it in because, again, once the parties agree, that's what the contract is. You can talk about terminating the contract based on if the other company has bankruptcy issues. If they go into bankruptcy, Can you now terminate the contract, or now are you still obligated to go into business with this person? There's just so many things that you can write in that are very business specific. All of these are very, very business specific, but it gives you an opportunity to know when you're in the right.
Right.
So that it's really, really important to have that, and procedures. So if my term is this, how can I terminate it? What procedures do I use to terminate? Is it written notice to the other party? An email is a written notice sometimes. You can have those procedures where you're in and you're out and you're done. Another part that the termination clause should have in it is what happens after termination. What happens? What happens if you still have to invoice the company? What happens if they still have payments that have to go back and forth? What happens? So, a lot of times I'll write for my clients contingencies for termination, meaning that if there are outstanding payments, they have to be issued within X period of time after the termination. Or if there's outstanding invoices that I need to send to you, I'll give you those within 10 days or whatever the case may be. And then you have to pay me immediately. So you not only have to address the term and the termination, but within that termination, you should address like notice periods. You should definitely address reasons. I mean, it's better. You don't have to have a reason necessarily, but if you put a reason that you want to terminate, then it makes it easier when the discussion comes up as to termination. And then you also want to make sure that you put in what to do afterwards. So term and termination is one of the must-haves. The content on Minding Your Business is for informational and educational purposes only and should not be construed as specific legal advice. This show discusses general legal issues affecting business owners. Opinions of the guests are not necessarily that of the show. If you need assistance with your specific legal issue, please consult with a licensed attorney.